Yes, good evening everyone. Welcome to the Banco Court. I'm Tony Payne. I'm a judge of the New South Wales Court of Appeal. This evening we're going to be discussing Australia's new anti-money laundering and counter-terrorism financing regime and its implications for the legal profession. I'd like to start by acknowledging the Gadigal of the Eora Nation, the traditional owners of the land on which we meet, and pay my respects to their elders past, present and emerging. So this evening we're going to proceed by way of a panel presentation, and the first speaker is immediately to my right is Brendan Thomas. We're lucky to have Brendan here. He commenced his 5-year appointment as AUSTRAC's Chief Executive Officer on the 29th of January 2024. And as the AUSTRAC CEO, Brendan leads Australia's Financial Intelligence Unit and Anti-Money Laundering and Counter-Terrorism Finance Regulator. AUSTRAC's regulation of the financial sector is hardened against criminal exploitation, and its intelligence provides information to national security, domestic and international law enforcement partners. Brendan is AUSTRAC's representative on the ACIC board, the Serious Financial Crime Task Force CEO board, and the Criminal Justice and Law Enforcement Forum. In view of AUSTRAC's role as a member of the national intelligence community, Brendan is also responsible for agency head level engagement with the Office of National Intelligence and other NIC members. Brendan is a Wiradjuri man with a significant experience in leading, designing and delivering major public services, especially in the criminal and civil justice systems in New South Wales, in leading organisational reform. Before his commencement with AUSTRAC, Brendan served as Deputy Secretary at the New South Wales Department of Communities and Justice, with responsibility for implementing major changes to reduce the overrepresentation of Indigenous populations in the New South Wales criminal and child protection systems. And prior to this, Brendan was the CEO of Legal Aid New South Wales and was formerly the Deputy Secretary of the New South Wales Department of Justice. Brendan's a Bachelor of Arts from Macquarie University as a Fellow of the ANZ School of Government. Brendan will address why Australia is strengthening its AML CTF regime and how lawyers can be exposed to money laundering risks. He'll explain the new obligations for legal practitioners from July 2026, explain red flags, reporting requirements, and how AUSTRAC will support the legal profession through guidance, tools, and a risk-based regulatory approach. Immediately to my left is Juliana Warner, be well known to many of you, is the chair of the Law Council of Australia's AML CTF Working Group, which has practitioner members from all states and territories. She was a partner of Herbert Smith Freehills, of course now Herbert Smith Freehills Kramer, for 30 years, practicing in commercial litigation, and worked on a number of high-profile AML CTF cases and matters. Juliana was managing partner of the Sydney office of HSF from 2012 to 2020. She was president of the Law Society of New South Wales in 2021, director of the Law Council of Australia from 2019 to 2025, and president of the Law Council of Australia in 2025. She's currently a member of the Legal Services Council established under the legal profession Uniform Law. Now, Juliana will address the legislative framework of the new AML CTF regime insofar as it will apply to the legal profession, the provisions relating to designated services, carve-outs and exclusions, the AUSTRAC reforms guidance, which, as you'll hear, is critical in the way this thing's going to work, at least initially, and its application to different areas of practice. Juliana will also address suspicious matter reporting and propose changes to the Australian Solicitors' Conduct Rules, which will seek to accommodate the new regime. On my far left is Catherine Gleeson SC, a senior barrister and member of New Chambers. She's a member of the Executive Committee of the New South Wales Bar Council and a director of the Law Council of Australia. In those roles, she's worked on advocacy and education in relation to the forthcoming regulation of Tranche 2 entities under the AML CTF Financing Act 2006. Catherine will address how the AML CTF regime will apply to barristers and litigation solicitors, including in criminal practice, legal professional privilege issues, and tipping off. And on my far right is Bobbie Wan, and Bobbie's the head of regulatory policy and strategy at the Law Society of New South Wales. Bobbie's responsible for developing legal policy, research and advice concerning the uniform law and other regulatory issues affecting the New South Wales profession, including reforms to Australia's AML CTF regime. Bobbie's also responsible for the strategic oversight and delivery of the professional support unit's services to solicitors in the areas of ethics, costs, regulatory compliance and AML-CTF, including developing and implementing strategies to enhance those services and ensure they align with the New South Wales Law Society's regulatory and other objectives. Before joining the Law Society, Bobbie was a senior advisor at various government agencies and worked on legal policies and legislative reform on a range of issues, including child sexual abuse, image-based abuse and forensic mental health. Bobbie's topic tonight will address the interplay between the AML-CTF regime and the Privacy Act. Now, we have a great deal to get through, as is obvious, and we have a slide presentation, and so I'll hand over initially to Brendan.
Thank you very much, Justice Payne, and thank you so much for generously hosting us here this afternoon in this court. I'd also like to acknowledge the Gadigal people whose lands we're meeting on today and pay my respects to the Gadigal families of Sydney, to the heritage of the Gadigal people and the spirit of this wonderful country that many of us get the great opportunity to work and live on. As Justice Payne mentioned, my name is Brendan Thomas. I'm the Chief Executive Officer of AUSTRAC, and we are both Australia's regulator for AML as well as Australia's financial intelligence unit. And today I'll talk to you about several important areas to help ready yourselves for the forthcoming anti-money laundering and counter-terrorism financing reforms. And my aim is to equip you with some practical knowledge and context needed to prepare for and thrive under this new regulatory landscape. However, obviously I won't be providing legal advice or speaking on scenarios specific to individual businesses. And there are several resources, and we'll talk about those in a moment, to support you available through the AUSTRAC website. Australia's AML-CTF legislation's core objective is to deter, disrupt, detect money laundering, counter-terrorism financing and the crimes that they enable. Over time, the regime has evolved to address changes in technology, business practices and the emergence of new risks. But the challenges of disrupting money laundering are not unique to Australia. Lawful domestic financial channels remain fundamentally important pathways for money launderers to place, lawyer and integrate funds domestically and internationally. Our stable political system, our open and free economy, our independent legal system, our well-developed financial services sector and our strong real estate market make Australia a great place to do business. But these features also make Australia an attractive destination to store and integrate criminal proceeds into our financial system. Drug offences are the single largest source of money laundered in Australia, but there's also significant money laundered from tax and revenue crimes, government-funded program fraud, proceeds of illicit tobacco sales, and the global proceeds of scams. Criminals are persistent in their exploitation of channels that have historically been used to launder funds, such as banks, money remitters and casinos, as well as high-value assets such as luxury goods and real estate. Criminal use of digital currency exchanges, unregistered remitters and bullion dealers is increasing and posing even greater risks. The lack of money laundering controls in non-financial businesses has created significant holes that many criminals are simply walking straight through. This is why the government has legislated these reforms. And we in AUSTRAC see professional facilitators being used to launder money consistently. And the money being laundered in Australia is extensive. If we look at just one crime type alone, drug dealing, we know through the work of our colleagues at the Australian Criminal Intelligence Commission that the value of the Australian domestic drug market is at least $12 billion a year. So think about that. That's $12 billion. Every dollar of that is illegal. And every dollar of that needs to be laundered through the Australian economy every single year. And that's only one type of crime. In 2023-24, serious and organised crime cost Australia up to $82.3 billion. That's 3.2% of Australia's gross domestic product. A further specific money laundering threat is that a number of Australia's illicit markets are linked to criminal markets and organisations operating in Asia. These include large and highly functional international drug trafficking organisations that control supply chains into Australia, as well as highly organised and sophisticated professional international money laundering organisations that have demonstrated capacity to launder funds into and out of Australia. That is, organisations that just launder money. They purchase cash from drug dealers and criminal organisations, and they launder money for profit and are constantly looking for holes in our financial controls to launder those billions of dollars. To give you an example of the scale and sophistication of money laundering operations, one such operation that was dismantled in Australia by the Australian Federal Police with AUSTRAC's assistance operated as a criminal remittance and banking service, able to make significant sums of money available to clients almost anywhere in the world within 24 hours. The organisation moved an estimated $10 billion over 4 years and had the capacity to move up to $1 million an hour. This organisation was so large it even set its own international exchange rates. The organisation had a sophisticated informal value transfer system in place to make funds available overseas. And by exploiting digital currency trading, domestic and foreign shell companies, and multiple offshore bank accounts, the organisation effectively operated as an underground bank with global reach. Organised financial crime accounts for $13.2 billion, with illicit tobacco, intellectual property crime, environmental crime, firearms trafficking, and pure cybercrime accounting for an additional $8.6 billion. Globally, conservatively, estimates at the money being traded, illicit money being traded, is $2 trillion. Currently, the focus of Australia's AML legislation is primarily on traditional financial institutions and services, such as banks and casinos. However, as criminal methodologies have grown more sophisticated, it's become clear that gaps still remain. And these include various crime enablers that may be unknowingly directly linked to serious and organised crime, including money laundering and professional facilitators such as launderers, accountants, and real estate agents. The Australian government has recognised these vulnerabilities and, through these recent legislative amendments, has moved to align our national framework with global and international standards. These most recent reforms passed, as you know, in November 2024 and mark this historic expansion, bringing a broader range of professional service providers within the scope of Australia's AML CTF regime. And this expansion is not merely legislative housekeeping. It's a necessary response to the increasing complexity and the scale of financial crime in Australia and globally. Australia's compliance with AML CTF is governed by standards set by an international body called the Financial Action Task Force, or unfortunately FATF for short. FATF is a global body established by the G7 in 1988 to set global money laundering and terrorism financing standards, and it is effectively the global regulator and watchdog. And it evaluates countries' performance with these standards. And Australia was only one of 5 countries that hadn't expanded money laundering regulation to these businesses. And the regulations and the legislation that the government passed in 2024 is bringing Australia into line with these global standards. That FATF will be doing an assessment of Australia's compliance with global money laundering standards starting this year and completing next year. And these changes bring Australia into line with those global standards. And Australia is, in fact, one of the last few countries to introduce these standards. The only others that are still outstanding are China, Madagascar, Haiti, and the United States. But our intelligence regularly uncovers criminals laundering, not just the proceeds of Australian crime, but we're seeing the proceeds of international organisations being laundered in the Australian economy. The reforms to the AML CTF Act aren't just about stopping Australian criminals, but they're about stopping international criminals parking their dirty money here. If we're seen as a weak link, and we have been in the past, we're a target for global criminal networks and risk losing credibility with other countries and financial institutions, resulting in these countries not wanting to no longer transact with us and to increase the cost of doing business with Australia. Legal professionals play a crucial role in financial and property transactions, corporate structuring, and trust management. Unfortunately, this expertise and access also makes the sector a target for organised criminals to seek to launder illicit funds. A criminal may seek legal assistance to appear legitimate in their illicit transactions. For example, a legal service may be used with the intention of transferring funds through a law firm's customer accounts. This could be done to either legitimise the funds or to use the firm's professional status to enhance the legitimacy of a transaction. Money laundering is facilitated by concealing the connection between perpetrators and the proceeds of their crimes. Lawyers may unknowingly be involved in money laundering activities when their services are used for depositing, transferring or withdrawing funds. The money laundering process typically involves 3 stages: placement, layering and integration of illicit funds. In placing money, criminals introduce illicit funds into the financial system, often by exploiting lawyers, for example, to establish corporate structures, trusts, and by using trust accounts to disguise the origins of those funds. When layering funds, funds are moved through complex transactions such as loans, consulting fees, and property investments to obscure their source. Examples include the use of straw directors, shell companies, and the transfer of funds through legal practice trust accounts. In integrating money into the legitimate economy, the funds appear legitimate. They're used to purchase assets or reinvested into criminal enterprises. A notable case involved a Tasmanian drug dealer using a lawyer's trust account to conceal the proceeds of crime in a real estate transaction. The legal sector's involvement in creating legal structures, facilitating real estate transactions, and managing client funds makes it uniquely vulnerable to money launderers. Law enforcement agencies are consistently identifying criminals seeking to exploit the advice and services of lawyers to legitimate their activity and to obfuscate the proceeds of crime. Intelligence from our colleagues highlight a case where a senior partner in a medium-sized law firm was abused by her client. She was on a visit to a bank that she was acting for, and in that visit, a director of that bank introduced her to a potential client, saying that he required the solicitor's services. The solicitor agreed to act for that client. She decided to forego the usual customer due diligence checks that she would normally have done when she was informed that the client had accounts with at least 2 major banks and was recommended to her by a regulated professional. Over the next 3 years, the solicitor acted for the client in straightforward commercial matters. One day, the solicitor was contacted by the police. They advised that they were investigating the client for suspected involvement in a fraud ring. Shortly afterwards, the client called to ask the solicitor to transfer a significant sum of money she was holding for him into a client account in an overseas bank. The solicitor clearly felt uncomfortable doing this, but felt she had no choice but to follow his instructions. The solicitor should submit a suspicious matter report in these circumstances. The report would not contain legally privileged information, but would highlight a large overseas transaction and police contact. Proper application of customer due diligence before agreeing to act for the client may also have protected that solicitor from having her services misused and from escalating to the point where she felt she needed to act against her better judgment. These steps are used by criminals to ensure the funds can be integrated and realised in the form of asset purchases and reinvested back into their criminal activity. In another example, the ATO, the Australian Taxation Office, commenced a risk review into an individual taxpayer suspected of tax evasion. When the ATO made contact with the individual taxpayer, the person was represented by a lawyer. The ATO ran the lawyer's name through the AUSTRAC database and identified millions of dollars in wire transactions between a lawyer's trust account and an offshore bank account. The bank with which the lawyer's trust account was held had submitted international funds transfer instructions to AUSTRAC. However, the bank was unaware of the source of those funds and that they had come from another institution. That meant they were unable to establish where those funds had come from. It was only when the ATO had already taken an interest in the individual taxpayer based on their sources of intelligence that they were able to draw the link between the individual taxpayer and this substantial amount of suspected diverted taxable income going through the legal trust account. Now, as part of the AML CTF reforms, lawyers and law firms providing designated services will now fall under the AML CTF Act. And examples of a designated service, and Juliana will talk about this, are assisting a person in planning or executing of a transaction to buy or sell a body corporate or a legal arrangement, assisting in the planning or execution of the creation or restructuring of a body corporate or a legal arrangement. Red flags or suspicious matters may arise from various context-specific scenarios relating to client behaviour, their source of funds, and the nature of their transaction. It may be a red flag where your client is evasive about the nature and purpose of their transaction, or where your client appears reluctant to provide information. Other red flags include the client that appears unconcerned or lacks knowledge about the transaction, where the transaction is unusual for that specific client, or the type of business or the age of their business, where there are unexplained payments from third parties, where there are large cash payments, connections with jurisdictions that are subject to sanctions, or where there is large drug production, terrorism or corruption is prevalent, or there is a lack of overall AML regulation. Being aware of these indicators or the warning signs of money laundering and terrorism financing should assist you in applying a risk-based approach to meeting your obligations under the AML Act and rules. If the lawyer mentioned previously had previously been subject to regulatory rigour, they would have identified the channeling of significant funds through their trust account to an offshore bank account of that client as potentially high risk and a red flag. Additionally, they would have had an obligation to undertake enhanced customer due diligence, including taking reasonable steps to identify the source of that customer's wealth and analysing the purpose, the reasons for and the nature of those transactions. This may have led to an earlier detection of criminal activity and the prevention of further proceeds travelling offshore. I'll leave my part of the discussion there and come back a little later about specific obligations.
Yes, we'll now move to Juliana Warner, who's going to give an overview of the structure of the legislation and the scope of the application of the extended regime, and we'll have a brief look at the relationship between the text of the legislation and the reform guidance, which I noted at the outset is going to be critical in the early stages of the implementation of the legislation.
Alrighty, well, I have quite a lot of material to cover, so as does Kath and Bobbie, so we're going to go through it at a fair clip. Luckily, it's going to be, the slide deck is reasonably comprehensive. It is going to be on the LCA website for you to have a look at your leisure. There are 4 key parts to understanding AML CTF, the regime. There's the Act, the rules, the guidance and the starter kits. And not all of it will apply to you, but you will need to do a whole lot of work to get across it, and it's really important. The guidance and the starter kits are critical for reasons that will become obvious, and I do want to congratulate AUSTRAC for having put in the effort to prepare this material. One of the upsides of being a later adopter of the AML CTF regime is that we can avoid some of the debacles that have happened in implementation in other countries, and giving assistance to the profession is vitally important there. So there's a phased transition for the Act ending on the 1st of July 2026. What's already in force is, and I'll just hit the high notes here, the Schedule 9 investigation and examination powers. AUSTRAC now has the same, in fact more, investigation and examination powers as the ATO, AUSTRAC, the ACCC and ASIC. In fact, I actually think it has bigger teeth. On the 31st of March 2026, enrolment commences for the Tranche 2 entities. That's us, lawyers, accountants, real estate agents and some other people that aren't really very much like us at all. 1st of July, commencement is the commencement date for the Tranche 2 entities. We've got some transitional rules that are pending, but there's a lot happening in the next few months. The Act regulates reporting entities. A reporting entity is a person who provides designated services to the Act generically refers to customers, but I keep saying we have clients, not customers, but in any event, read clients, the customers. If you are a person that provides designated services to clients, the regime applies to you in relation to the designated services that you provide. So what are they? The regime is designed to give effect to the FATF recommendations, which includes the interpretive notes, which establishes the international standards to address MLTF risks, and it's predicated on the risk-based approach. And there's a lot in the materials about the risk-based approach, which means that you have to identify, assess and understand the risks you may be exposed to, and then adopt appropriate measures to deal with it. Section 6 of the Act contains tables setting out what a designated service is in the context of specific industries and who the customer of the service is. But Section 65B contains the provisions for the newly regulated professional services which are relevant to the legal profession. On the next 3 slides, I've actually set out Table 6 professional services. I suggest you print them off and stick them up on your wall because they're worth remembering. Item 1, assisting a person in the execution of a transaction to do with real estate. Item 2, assisting a person in the planning or execution of a transaction to do with transferring a body corporate or legal arrangement. Item 3 is receiving, holding or controlling or managing a person's money and so forth. Think trust accounts at that point. Item 4 is assisting a person in organising, planning or executing a transaction for equity or debt financing. Item 5 is selling or transferring a shelf company. Item 6 is assisting a person to plan or execute or otherwise acting on behalf of someone in the creation or restructuring of a body corporate or a legal arrangement. For example, establishing a trust is an item 6 service. Item 7 is acting on behalf of a person who's a nominator in relation to as a director or secretary of a company, as a power of attorney, as a partner in a partnership. It's basically doing something on behalf of somebody else. Item 8 is acting as a nominee shareholder of a body corporate. And item 9 is providing a registered office or principal place of business. I don't know if anybody still does that, but if you do, it's a designated service. There's a court order exclusion. Items 1, 2 and 3, that's real estate, transfer of corporations, and that some of the trust account provisions do not apply if the designated service occurs pursuant to or resulting from a court order or tribunal order. Item 3 has a whole series of carve-outs in relation to what's not covered that's in section 6, bracket 5, capital C, bracket, and 5D, and I'll go through them in more detail a bit later on. So, moving on to what is the scope of application of Table 6 to legal practitioners? Well, essentially it is somewhat unclear. There are some words used in the items that are capable of an extremely wide interpretation, which, if it applied, would catch activities with no or negligible MLTF risk and have absurd results. Assisting a person could conceivably catch anyone who provides any legal assistance to a client that is related to a designated service. It also goes further than the FATF recommendation, because the FATF recommendation refers to preparing for or carry out transactions, not assisting with. So there's a couple of things that are still unclear about all of that, but AUSTRAC helpfully has developed and published reformed guidance which is clarifying its interpretation of the reforms. And how AUSTRAC is interpreting this is that assisting is confined to directly advancing a designated service, as opposed to activities which merely influence an outcome. So there's got to be a causative link to a transaction. Assisting, planning, organising, or otherwise acting for or on behalf of a person are only regulated when the action is sufficiently linked to the outcome of the designated service. And the actions will only be sufficiently linked when the following principles are met. The WHO principle: a person whose assistance to the client is directly advancing the designated service. Merely influencing how the client proceeds, providing general advice or ancillary services isn't sufficient. So who is the WHO? The WHO is the person who is actually running the transaction. Then there's the when principle. The person starts to provide one of the designated services when they act on instructions in relation to a relevant transaction or the creation or restructure of a body corporate or a legal arrangement. There is some complexity around that. But by confining assisting to directly advancing a transaction and distinguishing activities which merely influence an outcome, the items are construed as requiring a direct relationship between a service and an outcome to be engaged. Now, in due course, I think the legislation should be amended for clarity. But in the interim, is there a basis for AUSTRAC's more confined interpretation. At this point, I'll take a deep breath and say, having regard to the text, context and purpose of the legislation, which is to implement the FATF recommendations predicated on the risk-based approach, we think the better view is yes, there is a proper basis for this. Further, AUSTRAC is an enforcement body with extraordinarily wide powers, so what AUSTRAC thinks carries great weight. If AUSTRAC thinks this is a goer, we'll go with it. So what does that all mean? Well, it's complicated. While some legal services are clearly covered and some are not, the starting point will be for individual practitioners to assess the legal services that they provide and determine whether those services may be designated services in the circumstances in which they are provided. The reforms guidance assists by providing generic examples, some of which are applicable to financial planners and accountants and which need to be tailored to the application to lawyers, but they do shed light on which legal services, depending on the facts, are likely or unlikely to be designated services. And I'll make this very clear now, Brendan, we will need more sector-specific guidance. Thank you. So I'll give you some examples of what's unlikely to be a designated service. Legal aid services, which is a big relief. Generally, legal aid services are unlikely to fall within the scope of designated services, and we understand AUSTRAC has informed the legal aid commissions of this. I'm not sure where you're up to with the CLCs.
Still looking. Are more complex.
Are more complex, work in progress. A lot of this is still work in progress. Alternative dispute resolution, the people providing alternative dispute resolution services, negotiators, mediators, arbitrators, that kind of thing, that's unlikely to be a designated service. It's when the person who is actually doing the transferring of the property that there's an issue. The provision of template legal documents, which sometimes happens by subscription from one legal services provider to another. If it's just a template and it's going to be tailored and there's other bits and things to be added to it, and there's no relationship between the person providing the template and the ultimate client, that's not a designated service. Acting as a director in a personal capacity and not as a nominee of another is not a designated service. An executor under a will pursuant to a grant of probate is not carrying out a designated service, nor is a trustee for sale appointed by a court. You'll remember I referred to powers of attorney before, but preparing a power of attorney for a natural person is not a designated service. Now we get on to the curly stuff, which is advisory services. Purely advisory services that do not directly advance the transaction will not constitute a designated service, but merely influence the outcome. Here's an example which we have come up with by applying the principles in the reforms guidance. A lawyer conducting a transaction in progress seeks external advice from an ancillary advisor, for example, a tax lawyer or an intellectual property lawyer, on a specific aspect of the matter, such as the terms of the agreement. While the first lawyer is providing the designated service, that's the who, the ancillary advisor is not providing the designated service. But as with everything, in everything that we do, it's a question of fact and a question of degree. So, some further things that are not a designated service. Drafting a will, including a testamentary trust, is not a designated service. It's excluded from the definition of express trust in the Act. Obtaining grants of probate, this is all relevant specifically to wills and estates practice. You should all be quite pleased. Obtaining grants of probate, letters of administration and ancillary work to obtaining them and administrating deceased estates is unlikely to be a designated service where it involves a court order. If there's no court order, that's still up in the air. Transfers by survivorship, that's not a designated service. Holding estate monies in a lawyer's trust account pending distribution to beneficiaries we think are unlikely to be a designated service, provided there's nothing else going on in the administration that would constitute a designated service. And I think that's quite important because I understand that a number of wills and estates lawyers do have estate monies in their trust accounts pending distribution. What is covered, though, in wills and estates practice is transfers into vivos and creations of trust for estate planning. There is some complexity around it as ever, but we will keep talking to AUSTRAC about it. The next topic is family law. Family law is going to be quite pleased about this. It's good news. Here's an example from the Reforms Guidance. A lawyer providing advice to a husband in relation to the family home is not a designated service, as no real estate transaction is being directly advanced. After a mediation, the lawyer drafts a consent order to settle the proceedings, including providing for transfer of the property, also not a designated service. The court makes the order and the property is transferred pursuant to this order, not a designated service because of the court order exemption. So that should take a lot of basic family law matters out. Binding financial agreements is another example where a family lawyer provides work in drafting and executing a binding financial agreement in relation to a transfer of property. That's not a designated service because it's not performed in connection to a transaction. However, the conveyancers or lawyers' services to directly advance the transfer of the property pursuant to the financial agreement, if there is no court order, is a designated service. So there's going to be some further LCA advice on guidance prepared on that, and hopefully that will come up also in the further guidance from AUSTRAC. Commercial lawyers. By and large, if you're a commercial lawyer, you're going to be providing designated services one way or the other, and there's just a list of them. There's a few curly bits. Item 2 refers to transferring shareholdings. The Reforms Guidance refers to transferring a controlling interest, but the legislation only refers to a transfer of a body corporate. So we've been talking to AUSTRAC about that because we think that's something that you might need to amend the Act for. There's also an issue about when, with commercial transactions, when does the service commence? And there's not a lot of guidance regarding specialist advice. And as I said before, it's likely will come down to a question of fact and degree. But we do have some examples coming from the Reforms Guidance. So here we have an accountant providing tax advice to a client on the implications of selling a body corporate. Though this may potentially be influential to the client deciding whether to sell a body corporate, it doesn't directly advance any related transaction, and there isn't a related transaction. There isn't a transaction at this point, so there's no designated service being provided. You can see you've got to keep your wits about you with this stuff. But once it's clear that there's a buyer and a lawyer is instructed to act for the client, to sell a body corporate to a buyer, the lawyer commences to provide a designated service from that point. If there are many potential buyers that have been identified, the service begins when negotiations begin. This is why you're going to have to study the guidance quite carefully. Another example is once you've got a designated service that has commenced and you've got the who principle satisfied, so you've got the who is doing the transaction, then the preparatory steps taken to assisting in the sale of the body corporate will be regulated. And they're regulated because they go directly to advancing the outcome. With an ancillary advice being provided to a lawyer who is directly advancing the transaction, that's probably not a designated service, but it's a question of fact and degree. So you might be able to get advice on specific terms, for example, from a barrister or from a tax lawyer and so forth. Moving on to conveyancing, how are we going for time? Moving on to conveyancing services and transactions are at the heart of designated services. Relevant activities include the typical steps taken in the conveyancing process, and I've listed on the slide the usual kind of stuff. Now, whether the activity is regulated depends on when the directly advancing threshold is met. And on the next slide, I've picked a couple of examples from what AUSTRAC has had to say, and I'll draw your attention in particular to the second dot point, which says the transaction will typically exist where there is at least one buyer and one seller. You don't need to be specifically identified. And in a private treaty or where an auction doesn't meet the reserve, when the buyer and the seller, verbally or in writing, agree to the sale price of the property prior to payment of any deposit or the exchange of contracts. This guidance was given because we were very concerned about the prospect of a lot of people attending auctions and going to lawyers and a lot of services having to be done and not knowing whether they were designated services. So AUSTRAC has said, no, it's not a designated service in those circumstances until you've got the buyer and the seller and the price for the conveyancing transactions. If the auction meets reserve, at that point the buyer is successful at auction and the designated service starts then. The next slide is another example which really highlights this difference between the designated service and what's influencing. So the buyer is successful at auction. At that point, the lawyer will start to provide a designated service, but before settlement, the buyer expresses a little bit of regret and seeks further advice from an accountant for financial advice on the implications of withdrawing and another lawyer for advice on the legal consequences of withdrawing. These further services may influence whether or not the transaction will proceed, but they don't directly advance the transaction and they're not regulated. Let's move on to trusts. And moving quite quickly now. Setting up a trust other than a testamentary trust is a designated service. As I said, providing a subscription, draft deed isn't, and a transfer that arises by operation of law or creation of a trust that arises by operation of law is not covered. Let's talk now about operating trust accounts. Holding, controlling or managing a person's money or property that passes through accounts or dealing with money or property on direction of the instruction of the client in a transaction may constitute providing a designated service. That includes managing sale or purchase funds held in escrow or managing money or property prior to it being settled as trust property. Skip the next slide, please, because that's a double up. Yep, we moved to 34. But there are carve-outs. It doesn't apply to money on account for payment of fees and disbursements, including counsel fees. It doesn't apply to money received or money payable under an order of court or tribunal, for example, judgment sums or bail payments. It doesn't apply to money received from a government body, money received from an insurer, or money paid by the ATO. There's one particular unresolved query that we have, which is where a deposit is held in a solicitor's trust account when the solicitor is acting for the vendor, but is the solicitor also providing a designated service to the purchaser? That's an issue because how do you do customer due diligence on someone that is not your client? So that's one that we're taking up with AUSTRAC. Moving on to personal injury law, litigation services are unlikely to constitute a designated service and Kath's going to deal with that in more detail later. And then I think insolvency practitioners. Now, this is an area that the accountants are very interested in. I think this is still a work in progress at AUSTRAC. So I think we can't really volunteer anything at the moment about that. It's a TBC. And now, at this point, I'm going to hand over to Kath.
Thanks, Juliana. Hello, everyone. I too would like to very briefly acknowledge and pay my respects to the Gadigal of the Eora Nation and also to the custodians of the land of anybody who is watching us online. Now, I am going to address how the regime is going to affect both barristers and litigation solicitors. I'm going to spend a fair bit of time on the good news for barristers, and I'm sorry, litigation solicitors, in terms of the exemptions that are going to arise in the Act and the rules. Then I'm going to spend some time on talking about the way in which designated services apply to either barristers undertaking direct access work and also litigation solicitors. A lot of it will pick up on the themes that Juliana has just explained to you about the way in which transactions are to be approached. I'll start with the exemption that is in the Act. Section 66B provides that services provided by barristers on instruction of a solicitor are outside the scope of the Act. I've set out the relevant provision there. But you can see that there's a few elements to it. The first is that the service is provided by the person in the course of legal practice as a barrister. The next is that it's on the instructions of a solicitor, so that is our traditional means by which we undertake our work. But then there is the qualifier that the instructions must be given in connection with the provision of a designated service. Now, it stands to reason that if it isn't, the Act isn't attracted at all, but one does need to pay attention to the mode of the instructions and who is giving you the instructions to make sure that the exemption applies. But generally, the approach that one would prudently take if one was a barrister was to ensure that your instructions are given by a solicitor rather than on a direct access basis. I should just explain some of the reasons why this exemption is there. The first is that because of the nature of a barrister's work and the way in which we interact with clients, the likelihood that we both conduct work that carries an AML to CTF risk is fairly low because we don't facilitate transactions. That's not our work. The second is that because of the way in which we interact with clients, when solicitors are involved, we don't have a lot of control over doing the things that are required by the Act, for example, client due diligence. And then the third is if you're instructed by a solicitor who is discharging their obligations under the Act, it would be a duplication for barristers to do it also. Now, I just want to speak very briefly about the scope of the exemption. One of the really important things to keep in mind is that we're all used to, because the rules tell us that we can, accepting briefs from corporations with employed solicitors with a practising certificate and not making a direct access disclosure. Our reading of the exemption is that that is not the approach that you would take here. So if you have instructions from a bank being instructed by their in-house legal department, you need to think about who is the customer and who is providing the services to assist the customer. And you cannot be instructed by a solicitor who then has their own customer if the solicitor is employed by the customer, because they are the customer. There's no intermediary there. So that you need to take a different approach and assume that if there is a commercial entity, you are acting on a direct access basis and you'll need to comply with the Act. The next is that there is no exemption for pro bono services. That's because one of the integers of falling within the Table 6 services is that you're doing it in the course of carrying on a business, and AUSTRAC has taken the view that even if you're doing the work for free, it's still in the course of carrying on a business. That means, for example, that referrals under the legal assistance referral scheme administered by the courts, if you're doing that on a direct access basis, it is likely to be caught by the Act because, as we all know, a number of the court referrals can be made from the equity division, from the real property list, and potentially pick up some of the subject matter of the items in Table 6. We've been working with AUSTRAC on precisely when that work will and will not constitute a designated service. AUSTRAC's present position is that it probably doesn't, but there's obviously a risk involved if you accept a direct access matter without being prepared to comply with your obligations under the Act at any time where a designated service might arise, and I'll come back to that in a moment. But the ultimate thing to keep in mind is that if you're doing direct access work and it does not or is not likely to involve a direct access, a designated service, then it doesn't matter about the exemption. You can do the work because it's not going to be a designated service. There's some examples where you can feel fairly safe. Immigration matters is a fairly obvious one, but then there are others where it seems to be unclear. I will be quite frank. Pretty much the only direct access work I do is pro bono work, and I won't be doing it after this legislation commences because I don't want to fall foul of the Act. The next exemption, and I should stress that this is not one which is presently the subject of any legislation, delegated or otherwise, is in relation to government work. There's an exposure draft at the moment of a rule that will be put into class exemptions, which is some of the exemptions that are otherwise from obligations otherwise in the Act, is Rule 7.1, and it says that the Act won't apply to a designated service if, number one, it's a Table 6 service, so it applies to lawyers. Secondly, again, it's a service that's provided in the course of legal practice as a barrister. And next, the service is provided to an Australian government body. Now, what's an Australian government body? Section 5 of the Act has a definition which is commonly in Commonwealth Acts that an Australian government body is the Commonwealth, a state or territory, or an agency or authority of the above. The draft explanatory statement to the draft rules helpfully sets out AUSTRAC's approach to what that definition involves, so that one doesn't do the usual wending your way through a number of different cross definitions and separate acts and various authorities to work out whether or not the thing instructing you is in fact an agency or authority. For the Commonwealth, it's all non-corporate and corporate Commonwealth entities and government business enterprises, so it's very broad. For states and territories, it's government departments, agencies, offices, entities, and local government councils and authorities. So again, very broad. I'm going to come to legal aid in a moment, and Juliana has otherwise, but it's probably worth barristers bearing in mind that the Legal Aid Commission in New South Wales is a statutory corporation and would appear to fall within the definition of a state or territory entity at least. There is an exception in the guidance, which is that a company, trust, partnership or other entity created by a council or councillors in the exercise of their functions are not within the scope of the exception. So if you're taking instructions from government, insofar as it's a council, it needs to be from the council. I now want to move on. Oh, sorry, I should just say one other thing about the government exception. It is very good that barristers are likely to secure this exemption because of the difficulties we would have in performing a lot of government work for not terribly much money, and having that be the only part of our practice where we need to assume the obligations under the Act. That said, it does seem slightly curious that other legal practitioners instructed by government bodies would be encountering a situation where one needs to conduct client due diligence on the government and make suspicious matter reports about the government. As I understand, that's something that we're working on with AUSTRAC and may involve a slightly broader approach to that.
Yes, because that doesn't make any sense at all.
Now I want to just very briefly give an overview of the services that are likely to feature in litigation before drilling down to the guidance that AUSTRAC has given about how it's actually likely to play out when approaching your assessment of your practice and whether or not designated services will be involved. I've just set out very quickly there the 4 items that we have identified are likely to fall within the scope of litigation. And you can see they're items 1, 2, 4 and 6. I won't repeat them. Juliana's been through them. But when you go through them, it's pretty obvious that that's standard fare one way or another for most commercial solicitors and barristers. Then there's some things that we have identified that might engage Table 6 services, and then I'll come to whether or not they would in fact be engaged. The first one is in relation to what I might describe as their item 1 and 2 services, but this is effectively advisory work. For barristers, it's non-contentious advisory work. For litigation solicitors, it's likely to be something that is undertaken either as part of the resolution of proceedings or perhaps because you run the kind of practice where you do both litigation and advisory work. This is obviously subject to the principles that Juliana has elucidated about whether or not what you're advising on is a step that is designed to be influential to whether or not a transaction is entered into, whether or not it's part of carrying out the transaction, and whether or not if it is carrying out the transaction, it might be described as ancillary to the transaction. Most of the examples I can think of or have been involved in are likely to be when they're in the transaction, for example, somebody having a clause and needing to receive either advice about how that clause will be interpreted when there's a disagreement between the parties, people giving tax advice, and being brought in to do so in relation to some or all of the structure of the transaction. And many, many moons ago, when working for Juliana, I had the wonderful job of being the litigation liaison to due diligence work and going through anything that might present a litigation risk. It'd be things of that nature when you're a litigation solicitor. Then there's what's likely to be the hairy question, and that is when you are advising in relation to real property or other corporate work, corporate resolutions to disputes. So what happens when you are advising on and negotiating settlement agreements or family law agreements that will not result in a court order because you are settling a dispute by way of a deed and then having the proceedings dismissed. Then there is the items 6 and 4 and 6 work is again going to be either non-contentious transactional work, but significantly in relation to the last bullet point, when you're doing schemes of arrangement or other transactions which need to be the subject of court approval, that might create a real question, because the way in which those structures work is that you have done the transaction and then you're seeking approval of it. Barristers and litigation solicitors will be involved in that to varying degrees. Obviously, barristers usually get briefed for the approval stage. They're very often instructed by transactional solicitors. But there is a real question about whether or not that does have that requisite connection to bringing the transaction about. Having said that, I've never seen a barrister go direct access on a scheme of arrangement, so it's probably going to be okay.
In any event, this is all part and parcel of what AUSTRAC is going to be giving some further consideration to.
Again, these are just things to keep in mind when deciding whether or not you think you'll be caught by designated services. This is in relation to crime. If you're acting in bail proceedings, you might need to advise about sale or transfer of assets to facilitate bail conditions. If you're involved in proceeds matters, there's obviously going to be some advice given on transfer of property, and then there's sometimes property arrangements that arise in relation to the resolution of ADVO proceedings. Now, don't be fooled by the heading of this last slide. This is actually the important bit, and it's not just in relation to legal aid. Now, AUSTRAC has first of all said that its starting proposition is that dispute resolution in a litigation sense is generally not caught as a designated service because, firstly, it doesn't directly advance any transaction, particularly because it has only it generally relates to matters that have already occurred. That's effectively the point of litigation. They've then helpfully identified that when you are in the position in which there may be a potential designated service arising, it will happen in the course of settling litigation. And let's say that you are and this arose in Juliana's example in relation to family law. Let's say that you're engaged in negotiations for settlement and part of the negotiations involve the dispute being resolved by transfer of real estate. That does not directly advance the transaction. It influences the possible conveyancing process that will follow after conclusion of the proceedings, and that's likely to be the case whether or not that transaction is then embodied in a court order. That's quite helpful because that involves the period before any court order, and AUSTRAC has made clear that the court order exception in items 1 or 2 only applies to services that are carried out after the court order is made. Again, most litigation solicitors, unless you have a blended practice, are probably not involved in the post-court order process anyway. I just want to close the loop in relation to legal aid. As Juliana said, there is the very good news that it has been confirmed that work done by legal practitioners at legal aid will not trigger AML CTF obligations. So if you're a barrister retained by legal aid or you're a solicitor that does legal aid work, you're in a position of being confident that you are not going to be caught by this regime. There's obviously analogies there to other types of work such as community legal centres and other forms of court-mediated pro bono work. So we're working through all of these things. Just to summarise the approach that you can then take to assessing your practice and whether or not you are caught by the regime, you can proceed on the basis that in litigation you are unlikely to be caught, but at least at the moment until the guidance is finalised, there does have to be some level of caution about this because we all know that transactions do arise usually at the end of litigation, which is when we're thinking about resolving the proceedings. At the moment, all of the signs from AUSTRAC are that is unlikely to result in a designated service, but if it does, those instructions are going to arise well after you have been retained in the matter. And the way that AUSTRAC's regulation works, and you're going to find this out in a minute, is that you need to be ready to comply with your obligations as soon as you receive the instructions. So it's that timing issue that Juliana has referred to as well. You don't want to find yourself in a position where you've been acting for the client for months or even years, and all of a sudden you say, oh no, here's a designated service. I don't have an AML CTF program in place. I haven't done my client due diligence, and I haven't set myself up for some of the other monitoring and reporting obligations I've got. That's just not the way this Act works. So one needs to, when thinking about whether or not how it is that one sets up your practice when you're involved in litigation, you need to think about whether or not you will be involved in any work involving designated services and then approach the matter accordingly. If you're a barrister, the easy way to approach that is to have an instructing solicitor. If you're a litigation solicitor, you need to think about the way in which your practice might come in contact with designated services. I'm going to finish now, at least on this aspect. I do just want to say I have skated over this very quickly. If you're a barrister and you want to know more, Michael Izzo and or me have and will continue to give CPDs on this topic. I'm giving one in Newcastle on Saturday. There is an article in Bar News that explains the position, and there'll be what I'd like to call a final update once all of the guidance is in place and prior to the commencement of this part of the legislation at the beginning of the next financial year. Thank you, and I will now pass back over to Brendan.
Yes, so having sketched the outline, Brendan's now going to deal with the requirements to comply with the regime.
Thank you. So from the 1st of July this year, newly regulated businesses fall under this regime, and you need to comply with a number of obligations. The first of those is enrolling with AUSTRAC within 28 days of providing a designated service, and you can commence that enrolment with us from the 31st of March this year. There'll be a fair amount of assistance material provided to businesses to make sure that is as smooth and as straightforward as it possibly can be, but you do need to enrol with us prior to the 1st of July, but you can do that from the 31st of March. Secondly, you have to have an AML program in place. This program must include a risk assessment around money laundering and terrorism financing risks and include policies and procedures for how you will manage and mitigate those risks. And these policies must also ensure that you comply with your obligations, but that they are appropriate to the nature, the size and the complexity of your business. We've recently produced a range of starter kits, and if you're a small business, you can use those starter kits as a basis for your program. If you're a larger business, you can't use those starter kits completely, but you certainly can use them as a basis for your risk assessment and for your program. You'll also need to ask questions of your clients, understand the risks that they present, and be ready to report any suspicious activity to us. Those questions that you ask your clients are what we call ongoing customer due diligence, or CDD. And this involves verifying the identity of your clients and your understanding of the nature of the business relationships with them. In many cases, you may have been doing this already, and you may currently know who your clients are very, very well, and this obligation may simply amount to formalising your approach. But CDD helps you understand who your clients are and the money laundering or terrorism financing risks that they may bring to your business. The level of information that you collect and verify to complete that CDD will depend on the risk profile of your customer. Specifically, you need to establish whether your client or any agent of that client is who they claim to be, whether they're the subject of any financial sanctions, and whether they're what we call a politically exposed person. It's important to remember that we base this on a risk-based approach. This means that the level of due diligence that you do over your client will depend on the risk that that client poses. In many cases, we assume that your clients will be low risk. In these cases, you can apply less stringent due diligence known as simplified due diligence. From the information that we've got from the legal profession, most of your customers, we believe, will be low risk. These customers require much lighter checks, and in many cases, it'll be enough to gather some basic information from them, check their driver's license if they're individuals against this information, and do a couple of internet searches to see if they're subject to sanctions or politically exposed persons. While customer due diligence is vital, please remember we don't expect you to be police officers or investigators. You'll not be required to stop transactions to comply with your AML CTF obligations. It's really important to know. We've been regulating the banking industry for 20 years. We don't require them to stop transactions to comply with their obligations. And it's also necessary to state that we don't want to create any kind of duplication. We acknowledge that real estate transactions often involve multiple regulated entities. For example, one transaction may involve real estate agents, conveyancers, lawyers, and banks. Therefore, the requirement to collect and verify information multiple times will be inconvenient for customers, and particularly where there are several entities that are requesting the same information. As such, to avoid duplication, the law allows businesses to engage in reliance agreements or arrangements on an ongoing basis or on a case-by-case basis. This means that know your customer information verified, for example, by a real estate agent, a bank, or a conveyancer or a solicitor involved in a transaction can be shared with other regulated entities involved in that transaction to satisfy that CDD obligation. You will not need to perform CDD on existing customers. So it won't be necessary for any of those relationships that began before the 1st of July 2026 unless you need to submit a suspicious matter report about that client, or there is a significant change in the nature of the relationship that increases their risk to medium or high over the course of your business relationship with them. In that case, you would need to do additional customer due diligence on them. Legal professionals must submit suspicious matter reports and threshold transaction reports for cash transactions of $10,000 or more. If structuring is suspected, where clients break up large cash deposits into smaller amounts to avoid those reporting requirements, a suspicious matter report also needs to be lodged. You're required to have an AML CTF compliance officer in place responsible for overseeing compliance and acting as the main point of contact for AUSTRAC. And your staff need to be trained on your AML CTF obligations, the risks facing the legal sector, and your internal compliance procedures. We understand that this may be daunting and that these obligations are new. Quite potentially, the very concept of money laundering might be completely foreign to many legal practitioners. But it's important to understand that at AUSTRAC, we do not expect perfection from day one. We do not expect you'll be masters at identifying and controlling for money laundering risks. However, we do expect you to put in honest efforts to meet your obligations and to report suspicious activity to AUSTRAC. It's important to note many firms already have some of these policies in place, especially around client due diligence and record keeping. However, these must be reviewed now and where necessary, strengthened to ensure that they comply with these new obligations. So after the 1st of July 2026, we'll focus our enforcement efforts against entities that willfully ignore their obligations to enrol or to comply with, or who are willfully blind to money laundering activities. But at AUSTRAC, we're here to support you. We've developed a suite of support tools and guidance materials to assist you in meeting your obligations. These include our world first starter kit and program kits for legal practices. These kits provide practical step-by-step templates for small businesses to understand and build their AML CTF obligations, as well as to reduce time and the cost of compliance. The kits allow you to build and customise your own AML program and apply AML risk assessments, policies, procedures, as well as practical tools like forms to assist with compliance to these new obligations. Larger businesses can also use the kits as a foundation, but must demonstrate why the kit is suitable for their circumstances if they have more than, say, around 15 staff. We've developed these kits with industry peak bodies and small businesses across the newly regulated sectors and conducted quite extensive user testing and sentiment testing on the kits, and we've changed them quite significantly according to that feedback along the way. You can find these starter kits on the AUSTRAC website alongside a carefully crafted user journey and visual aids to ensure that you're able to follow these easily to assist with your compliance obligations. We've also developed detailed guidance documents covering risk assessments, program structures, customer due diligence, governance, and more areas. These resources are regularly updated in collaboration with industry associations and peak bodies like the Law Council of Australia and the various law societies around Australia. Complementing this, throughout 2026, we'll deliver a range of webinars, e-learning modules, fact sheets and checklists to support your understanding of this regime. And a phased awareness campaign we call Together We Can Stop Crime Where It Hides is underway to help all newly regulated businesses navigate this transition. And this is part of our broader public awareness campaign to assist the general public in understanding changes to money laundering laws and what also might be required of them in a range of different transactions. But I'd strongly encourage you to engage with AUSTRAC's guidance, attend and participate in forums, workshops and working groups to stay informed and engaged. I also encourage you to reach out to AUSTRAC with your queries. We are here to help you. I've increased the capacity of our contact centre. We've significantly expanded that, including its operating hours, to ensure that someone will be available to answer your questions. These initiatives are designed to ensure that legal professionals, regardless of the firm size or practice area, can access the tools and the knowledge needed to comply, to manage your risks, and to contribute to the national effort against financial crime. So our regulatory approach at AUSTRAC has shifted from being outcomes-focused and risk-based and designed to foster collaborative partnership with industry. Our goal is to support legal professionals in building robust compliance frameworks while ensuring the sector is not exploited by those who seek to undermine our financial system. Our priorities for the next year going forward include very strongly supporting newly regulated businesses and ensuring that you understand and begin to comply with your AML obligations and understand your risks. Applying a risk-based, data and intelligence-led basis for compliance and enforcement, and prioritising regulatory interventions for those entities who fail to enrol and are not making meaningful efforts to comply with their AML CTF programs. Our approach is supportive but firm, aiming for iterative improvements rather than immediate perfection. We aim to increase the proportion of businesses lodging high-quality suspicious matter reports with us. And we are actively identifying those areas where there's low or no reporting and taking action to improve that level of reporting. We continue to monitor and mitigate vulnerabilities in our financial system associated with large cash transactions, as cash remains a mainstay of money laundering activity in Australia. We're enhancing our regulation and oversight of digital currency exchanges and virtual asset service providers. They're increasingly at risk of money laundering and exploitation by criminal groups. And we're also strengthening our partnerships across the Pacific and Southeast Asian region to combat cross-border financial crime. But the legal profession stands at the front line of Australia's fight against money laundering and terrorism financing. The reforms to our AML CTF regime represent both a challenge and an opportunity. A challenge to adapt to new obligations and expectations, and an opportunity to enhance the reputation and the resilience of our sector. But I urge you strongly to engage with AUSTRAC's guidance, participate in our education programs, and work closely with your industry associations. Compliance is not a one-off exercise, but a continuous process of improvement. And at AUSTRAC, we're committed to supporting you every step of the way. And together we can make the legal sector a trusted pillar of our community and a barrier against organised crime.
Thanks. Bobbie Wan's now going to discuss the regime's interaction with the Privacy Act.
Good evening, everyone. So by now, I'm sure you're getting that sense that preparing for AML reform should probably not be left to the last moment or the very last second. For some practices, implementing the reforms might be relatively straightforward, and I'm sure aided a lot by the starter packs from AUSTRAC and hopefully by some supplementary guidance that the Law Society of New South Wales is also preparing. But for many others, there will be a number of issues to navigate. We spent quite a bit of time talking about scope of the regime, and that's a very important concept I think that we need to come to grips with, and it's a logical place to start because understanding the scope of the regime is key to determining the extent to which AML obligations will apply to your practice. And for many small practices, determining whether they come under the scope of the AML regime will also determine whether they have statutory obligations under the Commonwealth Privacy Act come 31 March, in just a few weeks' time. Many small law practices in Australia currently operate outside the scope of the Privacy Act due to a long-standing exemption that we've enjoyed for small businesses with an annual turnover of $3 million and under. This is commonly referred to as the small business exemption. However, this exemption does not apply to businesses if they are a reporting entity for the purposes of the AML Act. Put another way, you can assume that if you come under the AML Act, you will also have obligations under the Privacy Act. What we and the Law Council have been particularly concerned about is that many small practices are likely to find themselves needing to be compliant with not just one, but two new regulatory regimes in a very short space of time if they provide a designated service as defined by the AML Act. In other words, in becoming a reporting entity under the new AML Act, they will become an APP entity under the Privacy Act. APP, of course, stands for the Australian Privacy Principles, and so an APP entity must be compliant with the 13 privacy principles under the Privacy Act. Now, while I am not a privacy expert, we did know enough to be concerned about how the Privacy Act and the amended AML Act could potentially pull practitioners in two different directions if the regulators did not come together to provide joint guidance to practitioners. So, after all, and I've got that on my slide, a key object of the Privacy Act is to promote the protection of individual privacy and the transparent handling of personal information. While one of the key objects of the AML Act, as Brendan pointed to earlier, is to deter, detect and disrupt money laundering by supporting intelligence sharing. Now, that's not to say that the two pieces of legislation are incompatible or unworkable, but clear guidance is required, particularly for practices who will be navigating these regulatory frameworks for the first time. I'm therefore very pleased and grateful to AUSTRAC and to the Office of the Australian Information Commissioner, the OAIC, for agreeing to work with stakeholders such as ourselves, the Law Society and Law Council, to produce joint guidance to assist practitioners navigate their interweaving AML and privacy obligations. This joint guidance will be relevant to all practitioners captured by the AML Act, not just small businesses. An obvious point at which the two regimes intersect with each other is when you need to carry out due diligence under the AML framework. And that's because when you carry out your AML obligation for conducting customary due diligence, you will no doubt be collecting some personal information, such as your client's name, their address, their phone number, and perhaps even their photograph. So to help practices navigate these interlacing obligations, I thought I would share just 3 points to bear in mind when preparing your practice to be compliant with both the new AML Act and the Privacy Act. So the first thing to bear in mind is to remember that the Privacy Act does not prevent AML reporting entities from collecting, using, or disclosing personal information that is required to comply with the AML legislation. However, we all need to be very careful about treating this as a blank check to collect any or all information. Reporting entities need to determine whether collecting that information is reasonably necessary. And whether something is reasonably necessary is an objective test, requiring practitioners of reporting entities to consider whether a reasonable person who is properly informed would agree that the collection is reasonably appropriate and adapted to the circumstances. And determining this requires balancing in a reasonably proportionate way the potential impact on the individual, including the nature of the personal information and the extent of its use, including the nature and importance of the function or activity for which it is collected. In other words, whether you conduct customer due diligence on every new client after 1 July or just those seeking a designated service will depend on what's reasonable in the circumstances. For some firms, it will make sense to make that determination on an individual basis, depending on the service that the client or the potential client is seeking. But for some other firms, particularly your larger firms, it might make sense to conduct customer due diligence on all your clients. But they'd have to balance the likelihood of a designated service being provided, the interest of the individual and the client, including the nature of the information collected, against the purpose for collecting the information, which is not or not yet required. The second thing is that practices must have a privacy policy and collection notices with clear and transparent information on how they handle personal information for their AML obligations. The OAIC has produced a handy guide to developing a privacy policy, and that also has a privacy policy checklist, which I encourage everyone to have a look at. Your privacy policy should include how the personal information you collect is held, used, and disclosed. So, for example, you will need to inform your client the reason you are taking their personal information is to fulfill your obligations as a reporting entity under the AML Act. And if you have other reasons to collect that personal information, so if you are subject to other legislative requirements to collect that personal information, that should also be disclosed. We also suggest that you inform your clients that their information will be handled and stored in accordance with your practice's privacy policy. And as the object of having your privacy policy is to ensure that your practice is managing that personal information in an open and transparent way, it is recommended that it be plainly written and made available upon request. As an APP entity, but also as good general legal practice management, it is important to take reasonable steps to keep that personal information secure. Part of that security is limiting your collection of information to what is reasonably necessary. So if there's no reason to collect photos of your clients' children and their family goldfish, we would suggest that you don't do that. Similarly, if you find that you no longer require that information, say it's been 7 years since you provided your client, that certain client with a designated service, and you therefore have no obligations to continue requiring that information under the AML Act or under the Legal Profession Uniform Law or for any other justifiable reason, then according to the Privacy Act, you should delete or destroy that information. Now, in practice, that means that you will need to have systems and processes in place to specify retention periods and to consider from time to time whether the retention of certain information is necessary and ensuring that your staff are familiar with that policy. you should also have a data breach response plan. Having a data breach response plan will enable you to respond quickly if, touch wood, there is ever unauthorized access or disclosure, and it will likely minimize the risk of harm to the people affected and to your practice. The Notifiable Data Breaches Scheme, or the NDB, applies to all APP entities and it requires APP entities to notify affected persons and to the OAIC when a data breach has occurred that is likely to result in serious harm. Now, serious harm isn't defined in the Privacy Act, but in the context of a data breach, serious harm to an individual may include serious physical, psychological, emotional, financial, or reputational harm. The OAIC does have a guide to assist entities to prepare a data breach response plan. I also just wanted to point you to a few resources that might be helpful that the New South Wales Law Society has created. So we've been working with our Trust Account Department, the Professional Support Unit and Law Cover, and we've created a suite of resources to assist practices with dealing with cyber risk. So on our site, you will find a cyber risk management checklist for practitioners, as well as a guide for practitioners on how they can safeguard data and what to do if they fall victim to a cybercrime event. So in summary, my takeaway message is quite simple. AML reporting entities will also have privacy obligations commencing 31 March this year. So do bear that in mind as you prepare for compliance with the AML regime. And the second thing is that do keep an eye out. The OAIC will be issuing guidance specifically on how AML reporting entities should be navigating their obligations under the Privacy Act. And do try and check in regularly with the New South Wales Law Society's AML hub as well. We try to link to as much relevant information as possible. And once we become aware of the OAIC guidance and new AUSTRAC goodies to help us with our compliance journey, we'll be linking to that and updating our website with that. Thank you.
All right. Well, finally, from the panel, before we move to your questions, Juliana's going to discuss the suspicious matter reporting framework, compliance notices, and consequential conduct rule and retainer changes.
Okay, so now that you're reeling from realising that you have to comply with the privacy regime as well as the AML regime, let me take you back to suspicious matter reporting. Section 41 of the Act essentially provides that if an SMR obligation arises, you have to make a report. There's a lot of circumstances where that could arise, but essentially it will be if you think that the client or their agent is not who they say they are. So if you think you've got a phony person in front of you, that will give rise to a suspicious matter reporting requirement. If you have information, if you think you have information concerning the provision or prospective provision of a designated service that may be relevant to the investigation of tax evasion or any offence or the enforcement of the Proceeds of Crime Act, you have to report that as well. And if you think you've come across the provision of a service that is preparatory to the commission of the financing of terrorism and money laundering. So in addition to filing SMRs, you can be exposed to receipt of Section 49 and Section 49B notices. Now, the tipping off provisions of the Act so that you can't tell your client about it, and it's a criminal offence to do that. There are some exceptions. I mean, you can't tell your client or anybody else about it. There are some exceptions. You can disclose to a lawyer for the purposes of obtaining advice, and you can make a disclosure in good faith for the purposes of dissuading a client from engaging in conduct that constitutes or could constitute an offence. But that is pretty limited. So you've got to be very careful about this whole suspicious matter reporting area. There are unique problems arising for lawyers in making a suspicious matter report. There are ethical duties and professional responsibilities that we have that nobody else has, that mean that if we file an SMR or receive a Section 49 notice that we can't tell the client about, that is incompatible with continuing to act for the client. And I'll talk about that right at the very end. But Kath is going to quickly talk about client legal privilege, because you don't have to file an SMR if the entirety of the content of the SMR would be privileged. If it's not privileged, or not wholly privileged, you have to file an SMR in relation to the non-privileged part of it, but not the privileged part of it. So that does your head in working that out. So, Kath, maybe you can
Sure.
deal with that quickly.
Very, very quickly. Number one is that, as with all other regulatory acts, the AML CTF Act does not purport to abrogate legal professional privilege. You can see that in Section 242(1), which I've set out there. And in terms of disclosing to AUSTRAC that there is a potential privilege claim, articulating the basis of the claim would not of itself amount to a waiver of the privilege. And that arises in relation to the way in which the Act decrees that you are to deal with privilege claims. As Juliana said, that when you're making an SMR, if all of the information that forms the basis of your reasonable suspicion so that you have to make a report is privileged, you do not have to make the report. And you have to form a judgment about whether or not there's any non-privileged material that goes into the formation of the suspicion. Obviously, privilege is going to arise not only in relation to SMRs but also in relation to notices to produce or give information, and AUSTRAC's powers to issue those notices arise in a number of provisions of the Act. If only some of the information the subject of the SMR is privileged, or in all circumstances in which a notice to produce is issued, you must report, you must produce or give information in response to the notice, but you have to do it under cover of an LPP form, which makes a claim for privilege and sets out the basis of it. And I've set out the provisions there that provide for it in the Act. Those privilege claims will then be determined by a process which will be set out in guidelines that are yet to be published by the Minister of Home Affairs. So we're presently in the dark about whether or not that will be done by somebody designated to deal with the claim by AUSTRAC in an arbitral-like fashion, whether or not there'll be some form of mediation or whether or not it'll have to go to a court. But there are issues with it in relation to the tipping off provision, which applies not only to SMRs but also in relation to the production of documents under some of the notices. If telling your client, I've made a privilege claim on your behalf because I've had to give a report about you, is something that falls within the tipping off provision, you can't tell your client about the privilege claim and you can't get instructions. It's kind of a problem. The owner of the privilege is the client, and while you've got obligations to make privilege claims on behalf of your client, it is difficult to do so in the absence of any instructions. The other thing is that one presumably is both spending money making the report, spending money in terms of the time that you've dedicated making the report and preparing the LPP notice, and then you are going to have to go through the process again without instructions of resolving the privilege claim, and you can't ask your client to pay you for that because they don't know about it. There's then the question about, and we won't really know until there's consultation on the Minister's guidance, but what's going to be realistic in terms of resolving the privilege claims. We know that a number of regulatory bodies have made submissions to the Commonwealth Review of LPP and regulatory investigations. There is a sense that there's a real push towards that being resolved by a court. That's obviously going to be time-consuming and difficult, but AUSTRAC will have its own operational reasons for wanting to go down that road or to go down a more convenient road. We won't know, but it's something that certainly the Bar will continue to engage with AUSTRAC about, because it creates some serious problems in relation to our duties to our client that we would need to make privilege claims on their behalf in those circumstances. And I can go back to Juliana now in relation to conduct rules.
Okay, but just on this question about how any privilege claim is to be determined, it's fine for the ACCC and the ATO and ASIC and the like to want to have informal processes where things are done by agreement. And you can agree, the client can agree to give up a particular claim, and you can, sort things out in a sensible fashion. But no solicitor or barrister, for that matter, can make that kind of decision for a client because it's not our privilege. It's the client's privilege. So I think this just has to go. If there's a dispute about a privilege claim, it just has to go straight to a court. But we're waiting to see what happens with the draft guidance that will be coming. All right, so the last topic that I want to deal with is the conduct rule changes that we think are necessary because of the impact of the regime. In particular, they're to do with the fact that Law Council and all the state bar and law societies are of the view that you cannot continue to act for a client once you have dobbed them into the regulator, because it's just completely inconsistent with a whole suite of our obligations and duties. So if you want to terminate the retainer, how on earth are you going to do it and what on earth are you going to say to the client? Working through the rule changes, what we're trying to do, at least for solicitors, is to include in rule changes that there's some kind of disclosure in a retainer that is to the effect that, I, as a solicitor, am subject to requirements which may require me to report to various statutory authorities. And by the way, it's not just AUSTRAC. There are other statutory authorities already, such as the crime commissions, the various crime commissions, where you might have to report and you can't tell the client. Also, we think that there's likely to be a need for a rule change to take into account the fact that there's these ongoing customer due diligence obligations. And finally, we are proposing to change the rules in relation to when you can terminate, to expand the definition of just cause. Under the rules currently, you can terminate a retainer for just cause. It includes a variety of things, but we want to make explicit that it includes terminating a retainer where you can no longer act in the client's best interests. AUSTRAC in the starter kits has included in the policy section that you can make those kind of disclosures, which is good because that indicates that AUSTRAC does not consider that to be tipping off, which is an excellent result, which I'm very happy about. So the rule changes are still embryonic. There'll be, for the uniform law states, the process for changing rules involves really extensive consultation with local regulatory authorities and a variety of other stakeholders, including, I think, the courts. That consultation hopefully will commence soon, and if that's successful, it'll result in a proposal to the Standing Committees of Attorneys General for the uniform law states by the Legal Services Council. In the non-uniform law jurisdictions, which is everyone other than New South Wales, Victoria and WA, there's a similar but separate mechanisms for rule changes. So our consultations will commence shortly. So just in case I thought I didn't have enough to do,
all right, well,
we'll be doing more of that.
Tsunami of information that you've been hit with. We've got some time for some questions. There are some roving microphones. If you can identify yourselves if you'd like to ask a question and identify the member of the panel that you'd like to ask. I noticed some tax lawyers in the audience. As I'm reading this, it's a long time ago since I did a tax case, but whether I ever had any information concerning a prospective provision of a designated service that may be relevant to the investigation of tax evasion. I can barely think of a case where information that I had didn't meet that description, but that might say more about me. I'm sure that nobody else suffers from that affliction. Has anyone got any questions at all they want to ask? Yes.
I think I can project without the microphone, but can someone tell me whether there's going to be an obligation on barristers to ensure that their solicitors are complying with the solicitor's obligations under the AML-CTF legislation?
That's not what the legislation says. That's not how we're reading it. You need to be satisfied that they're giving you instructions in connection with the provision of a designated service so that the exemption applies, but that's all you need to know. We have been proceeding on the basis that we can trust our fellow legal practitioners to comply with their obligations, and there does not appear to be any expectation by AUSTRAC that we need to oversee or monitor the discharge of those obligations.
Thank you.
Yes.
Hi, just a quick question regarding money held in trust, but not on account of, paying for barristers, so for non-legal disbursements, but not for a transfer of...
I'm terribly sorry. Could you speak up? Yeah, just speak right into the microphone.
Sorry.
That's it. Yeah.
Sounded really loud here. What about money held in a trust account on account of non-legal disbursements? Is there going to be, some kind of list published of what will be covered? So say it's not covered by what we talked about today, so a transfer of assets like real estate or company assets or restructures. So for example, if we just have money in trust for payment of renovations or something, So we're just a bit confused in our law firm what will be covered.
I think if you've got money in trust about renovations, you should be thinking about whether you should have money in trust on account of renovations.
Yeah, but say it's for a retaining wall or something. So,
I think it's got to be for...
It's got to relate to a designated service. In the first place.
It's in relation to a designated service.
Good.
I think the panel thinks you're caught.
Hi. Hello. I'd like to express concern at the unreasonable and complex regulatory burden that's being imposed on sole practitioners. I've downloaded the AUSTRAC legal kit. That's it. 436 pages, 30 forms, and 9 documents. That's just unreasonable to expect sole practitioners to comply with on a beginning basis and on a continuing basis. What can be done to reduce that regulatory burden?
Shall I answer that?
Yes?
The starter kits that we've developed, which you're holding up, cover just about all of the legal obligations that most businesses face under the AML Act. We don't anticipate that most small businesses will need to comply with all of those legal obligations. So on that website, if you have a look at it, is a journey that should take you through how to use that kit, how to look at the services that you provide and where those services might expose you to money laundering risk, and what the nature of the controls are that you might need to have in place to address that risk. Largely, the obligations under that Act for small businesses are assuring yourself you're confident you know who you're dealing with and why you're dealing with that person, and doing that to an extent where you can assure yourself of that. And if you're not sure, taking additional activity to give yourself that assurance. And if through that activity you can't assure yourself that you're confident that this person or this business is who they think they are, then you report that to us. It's a regime based on escalating activity based on the level of risk that's in front of you. So if you do go back to our website and follow that customer journey, hopefully you'll find that it's a much simpler journey than simply printing out those 400 pages worth of documents and reading through all of those.
But I have to read the 436 pages to know what it is that I've got to comply with.
As I say, if you go through that customer journey, you'll find you don't have to do it.
On an ongoing basis, review every so often, and check this and check that. Tell me, how do I determine that some money that comes from Thailand from a client to buy some real estate, how do I check that that's clean money or laundered money? The bank won't give me any information about it. It's come through a bank account. How do I verify that that's clean money? This doesn't tell me how to verify that the money's clean. The only unclean money I could ever find would be if someone came in with a suitcase full of cash, I'd sell them, I'd buzz them off, or cryptocurrency, which I don't understand anyhow. It's coming from a bank. How can I determine the source of the funds and whether it's clean? You're the only ones that can access that, not me.
Make it quite confidential. Is that the question that we actually need to ask them? Where's the money coming from?
Yes.
And
I
that's
mean,
self-serving.
Yeah,
They say
that's the question.
I tell you, I'm
Tell me where the money's coming from.
yeah.
Please.
You can make reasonable inquiries to assure yourself that you're confident that that is legitimate. If you can't assure yourself that it's legitimate and you've got concerns that it's not, if you do have legitimate concerns that that's not legitimate funds, then report it to us. That's how you acquit that responsibility, is by reporting a suspicious matter to us.
And then you have to quit. That's unreasonable.
Well, I think you can do things like conveyancing lawyers do often with overseas money coming in from that is said to come from the settlement of an estate, for example, in the UK. This was an example that was given to me, and the solicitor made inquiries of the firm of solicitors in the UK. So she felt uncomfortable about it, and she made some further inquiries. But I think once you make your inquiries, I mean, you are entitled to assume that you don't have to assume that they're crooks.
No.
Just because it comes from another country. So, but it is difficult, and I completely acknowledge this, and I understand in particular the difficulties this is going to cause for sole practitioners. That's why we've been working so hard to try and make this as less onerous as it possibly can be.
That's not less onerous.
Well, I know.
There's 30 forms there that have to be filled out at various times.
But can I say, so most of those forms, as I say, they're there to help you acquit every one of those legal obligations. For most small businesses, there's 3 or 4 of those forms that they'll use most of the time. And other forms that, unless you're a high-risk business dealing with complex and risky transactions, you'll never come across. But that kit aims to provide you with all the resources you need, depending on the risk of your business, to be able to comply with the legislation.
Is there a key for a small practice separate from that?
Can we just sorry, just one at a time.
BMA House lawyers, for the record. I totally agree with the gentleman who made that comment in spectacles. Yes. Would it be possible at all to reduce that 140 pages designed for the practices in general, just for a small practice? So if that reduction could have been done by your office, it's just one sort of question. And the other related point, could you just comment or describe if suspicion transaction report has been made, for instance, is there a time frame for your consideration? I understand, correct me if I'm wrong, transaction has been completed at the end, suspicion arose. Do I use the grammar right? Yeah. And then you report, and then what happens? The client cannot be tipped off, cannot be given information about that. Let's put it aside because it's a terrible, situation in any case. I think everyone keeps in mind. And then what happens? Potentially, you investigate. I presume no time frame, and Crime Commission of New South Wales will issue freezing order if a report is successful. This is not a terrible definition. What does it mean, successful report? It means I adopt in my client, for use of better expression, Amanda, correct me, please. Amanda is from Australian Taxation Office. And, well, perhaps that is all. Could you just comment? What would be the successful report? What does it entail? So is freezing order possible, or, you know, we'd rather have an unsuccessful report on each occasion rather than successful?
Yeah. It depends on the nature of the suspicion that you've reported. So currently with the businesses that we regulate, we get around about 500,000 suspicious matter reports a year. And those reports vary from I'm dealing with a client and I can't establish who this client is, or I'm dealing with a corporate structure and I can't really determine who the beneficial owner of that structure is, all the way to I'm pretty certain I'm dealing with illicit funds and reporting the nature of those illicit funds to AUSTRAC. What happens with that report varies a lot. In some instances, there's a very detailed suspicious matter report that we get from businesses that report to us that lay out a whole range of elements of criminal activity. In others, it's merely a suspicion. That is, I can't see the source of wealth from this person. The way we use that information is often not in the individual, but in the aggregate. So if you're giving me a suspicious matter report about a person, it's often likely I'm also getting a suspicious matter report from a bank or another financial institution. And we use that information along with a whole range of other information we get from law enforcement and national intelligence bodies to build pictures of criminal behaviour, of criminal networks, of crime types. And that information goes to all of Australian police forces and national security agencies. And the way AUSTRAC provides that data, we provide it in individual intelligence reports to those bodies. But there's about 5,000 people who work in every Australian police force and every national intelligence body who directly go straight into all of our suspicious matter reports and have direct access to those. So all of those reports get used all of the time for either individual investigations or building criminal profiles of groups and networks. We also use them to identify channels of particular risk and identify where we might be able to strengthen our systems against channels of particular risk. So, for example, we get a lot of suspicious matter reports from banks around what we call mule accounts, fake bank accounts created by people. Those reports a year or so ago in the aggregate indicated to us that we had a problem with foreign students coming to Australia, opening bank accounts, and then when finishing their studies, selling those bank accounts to organised crime. With the banks, we were able to identify that pattern of behaviour through those suspicious matter reports, identify a whole range of red flags that banks now put into their transactions, and last year they closed 22,000 of those accounts before they were able to be used by money mules. So the reports are used for a whole range of different reasons. It's not just a linear report gets lodged with us, a criminal investigation comes and a person gets arrested. They're used for a whole range of different criminal intelligence and law enforcement purposes.
But in any event, from the solicitor's point of view, if you have filed a suspicious matter report, you have to cease to act.
Yes, the gentleman up here.
Would it be prudent for everyone at the bar to register between March and 1 July, just in case there's a possibility of a designated service? Is there any downside to that? But then would you only have to comply with the Australian privacy principles if in fact you are in the category of providing a designated service from that point and for the period you're providing the designated service?
No, please go on.
No, go ahead.
I was just going to say, it really depends on how you foresee your practice operating after commencement of the legislation. If you think you're going to operate your practice on the basis that you're going to work only on instructions from a solicitor, then I wouldn't have thought you needed to enrol. If you think that there's a significant component of your practice that is likely to involve designated services, you should definitely enrol. You've got to think about, I don't know how successful your practice is, but at the moment, unless you're earning more than $3 million, you're gross, then you're probably okay in relation to the Privacy Act. Brendan and Bobbie may be able to tell us about the intersection of the Privacy Act and whether or not it's triggered on enrolment or otherwise.
Yeah, it's not. If you're of the view that you provide designated services or are likely to provide designated services, there's no detriment in registering with us. So there's no negative consequence for you if you do that.
Although I suppose AUSTRAC would then expect you to do an annual compliance report, etc. Because
To the extent
AUSTRAC,
that you're providing designated
right. So AUSTRAC would assume that you're providing designated services, and so if you forget about it because you don't actually provide designated services, just be prepared you might be chased up. Well, where is your annual compliance report, etc. I imagine. In relation to your privacy question, my understanding is that your privacy obligations would apply to the extent that you provide designated services. So if you provide a mixed practice, non-designated services and designated services, my understanding is that your privacy obligations don't strictly apply to your non-designated services. Yeah.
Yes.
Yes. First of all, I'd like to thank you, Brendan, and the team here for this wonderful session. My question, I've got two questions. Firstly, in connection with the AML program. Obviously, AUSTRAC has released various starter kits. And for those who are advising, on the drafting of the program, are you able to sort of clarify as to what extent we can rely on the structure or the concepts being covered in the existing templates? And my second question is, I guess, reliance. It's about the reliance provisions. Clearly, we've got thousands of reporting entities as a result of this tranche 2 reform. So to what extent AUSTRAC is expecting these reporting entities to rely on one another? And further, is there anything AUSTRAC can do to sort of clarify the liability aspects of the reliance? Because that seems to be, to me, the problem between the existing reporting entities, because, there seems to be a bit of hesitation as to how that liability would be apportioned in the event of a claim.
Yeah. In terms of your first question, which is around startup programs and programs generally, you can use those programs to form the basis of a broader program if it's a larger firm. A key component part of that program is a risk assessment, understanding the risks that your business may be exposed to. And those risks really come in 4 areas. So the nature of the services that you provide, the nature of those designated services, what risks they might expose you to, the clients that you deal with, and the nature of those clients. So if you're dealing with individuals compared to companies, the channels through which you do services. So whether you're providing services in a face-to-face way or in a remote kind of fashion, and the jurisdictions that you do business with. If your businesses are entirely within Australia, or you're providing business services to places that have a higher money laundering risk. These are the kinds of risks that program should look at. And then the elements of the program are effectively how you do customer due diligence, how you train your staff around customer due diligence, and the systems that you have in place to escalate when you notice higher risks within your business. So where you take extra due diligence steps and when you would then report to AUSTRAC. They're essentially the elements of an AML program based on the nature of the services that your business provides. We've tried to do these starter kits based on intense discussion with small businesses so that they can cover everything, and that a business can pick up that kit, go through that user journey. It's on our website. Please go through that rather than printing it all out, because that's the way it's designed to be used, so that you can then lay out what your program is and where you need to focus your effort and where you don't need to focus your effort. Larger businesses can certainly use the elements of that starter kit to form the basis of their program. We'd strongly encourage people to do that because it is what we think about how you should start to meet those obligations. So you should be using that. In terms of reliance on existing regulated businesses, are you talking about the flow of information in real estate transactions in particular?
I suppose I was referring to reliance between, say, real estate agents and lawyers.
Yeah.
Clearly, one party is going to collect, verify, and risk assess customer. So to me, repeating the same thing over and over again, as a lawyer,
Yeah.
to me, it's a double up of the process. And that is not what's been, to me, contemplated under this reliance process. So if one entity is able to rely on the other, so long as, certain aspects of these liabilities and so forth are clear within the parties.
Yes.
So I was just wondering a bit more guidance. That's all I was trying to, I guess, clarify, because right now there's not a lot of guidance being provided. And to me, in order for, reporting entities to have that level of discussion, some guidance from the regulator would be appropriate.
Yeah, the legislation does provide for that kind of diligence information to flow with the customer through the course of that transaction. So if it's collected by one reporting entity with agreements, that information can flow. I mean, I'd advise you to do your diligence around who you have those agreements with, that you're assuring yourself that that body is doing that effectively and doing customer due diligence effectively. Perhaps look at their programs and make sure that it meets some basic standards. We'll take on notice whether we can provide any additional material to people for that better clarifies that and how that might flow.
All right, we have time for one last question then.
Given the runway is fairly short for implementation, particularly for large businesses who need to get a lot of people ready in 4 months, and the answer might be different depending on which side of the panel you're sitting on, but would the panel's view be that it's better for businesses to err on the side of caution and report rather than wade through all the detail that's still yet to be determined?
Are you referring to report matters of suspicion? Yes. If my advice is err on the side of caution and report. If you're suspicious about a transaction, or if you're suspicious about a customer, you're suspicious about a counterparty in a dealing, and in fact, when we speak to our colleagues in the UK and New Zealand, a fair majority of the suspicious matter reports they get are on counterparties in dealings, then file a suspicious matter report with us.
I won't answer it because a court is not a person, as is well known. Well, can I bring it to an end? Thanks for your close attention to this very important subject. It won't be the last you hear on the topic. You join with me in thanking the other members of the panel.